Good afternoon. This is Week 10, Laws 11057, Introduction to Law, and tonight we're dealing with the process of research for overseas jurisdiction, in particular the United Kingdom, New Zealand and Canada, and those issues which are dealt with in Chapter 7 of a practical guide to legal research by Milne and Tucker. I'm referring to the second edition, but there is the third edition available now. That commentary won't take long. I'd then like to discuss with you the response to the assessment, or not the assessment, but the assignment piece that I set for you for consideration in relation to following on from last week's discussion about options that might be generated for a client in circumstances where the client has now come back to you and said, I do wish to proceed, and what happens from there. I will mention that next week we'll be discussing, at this stage I propose two things, that is chapters 8 and 9 from the Legal Research Guide. That won't take very long. I'd then like to have a session dealing with ethics in a courtroom situation, and particularly contrasting your obligations ethically in a courtroom to your own moral standards, and that aspect will be examinable. Week 12, you'll be pleased to hear, will be purely a revision week, guided mostly by you if you're interested in letting me know what issues you have, and it'll be a discussion piece aimed specifically at the examination. So there'll be nothing new introduced in week 12. All right, well, let's commence tonight. Firstly, we'll see if there's anyone with any questions. They're not. We've got a number of people online, so thank you very much for joining us live. I'm just going to run through a few issues that I think are relevant from Chapter 7 of the book. Firstly, can I say that, as you might understand, the process of legal research has changed dramatically since when I was studying at university in the 1970s. Firstly, of course, back then it was all paper. Secondly, it all had to be done essentially in the library. You really didn't have any choice. There was no online facility at all. And thirdly, we had a considerable emphasis on decisions from the United Kingdom. So I would regularly be going to the All England reports, or the reports from King's Bench or Queen's Bench, or the weekly law reports, things of that nature. And to my experience in practice, we don't do that very much at all anymore. Back when I started studies, we were at the stage where the Privy Court was the highest court, and that is the court in England, which is equivalent to their High Court, and matters could go to that particular jurisdiction. That is no longer the case. So our own High Court is, and has been for many, many years, the highest court in this land. So reference to UK decisions is largely historical and provides some context, but progressively, year by year, it seems to me the relevance of decisions overseas is becoming less and less significant. So in the text, there's guides as to how to access the information from the UK, and there is the comment, and I think quite sensibly, that you must now bear in mind that decisions in the UK are subject to decisions of the European community generally, given that UK became a member of the community in Europe in 1973. So there is the jurisdiction of the European Court of Justice and the European Court of Human Rights, which will also work in. Also, the comment is made that unlike the time when I was studying in many years ago, the House of Lords is now a parliamentary as well as judicial body. It was purely a judicial body in a previous case. Now, you're all familiar, of course, with Ostley, and in England we have Bali. I'm not sure if that's the way they pronounce it over there, but Bailii, which is the equivalent of our Ostley. Also, of course, you'd be familiar with Halsbury's laws, and they're based on Halsbury's Laws of England, which is available through the library. The authorised legislation in the UK, I've never had cause to look at it, but it's www.legislation.gov.uk. Now, please let me know if I'm going too quickly through this brief commentary. So the unofficial source for legislation overseas is BAILII, that is in the UK. That's the Bali. jurisdiction. I've made comment in relation to the law reports. There were many different types of publications. We would go to reports based on Chancery or other types of reports, and eventually they were consolidated into what was, I think, the unofficial, but the All England Law Reports, which provided a consolidated database of various legal decisions in the UK. We also have JustCite, which is linked to Ostly, Time-Based, LexisNexis and Westlaw. All right, I know that's very brief, but that's all that I propose to discuss in relation to overseas jurisdictions. Now, are there any questions before I leave that issue of legal research overseas? All right, well, let's move on to our tutorial problem. And the issues that I wanted to discuss follow on from the issues from last week. You'll recall that last week I indicated to you that I wanted to have you essentially broaden your horizons in circumstances where you were to provide a number of options to a client who was seeking some sort of redress for a circumstance. And it may have been, you think, obvious that you advise the client to go to court or tribunal, but as we ascertained that that's only just one of a number of different options that might be and should be considered in the context of providing holistic legal advice. But now, having considered all those options, your client does say, I wish to go to court or I wish to go to tribunal, tell me all about it. So the first situation that we considered was your client wishes to pursue a debt of $5,000. Now, I'm looking for your further comments, and Gordon was after the URL for All England. Got it? Great. Thanks, Gordon. So your client wishes to pursue a debt of $5,000, and the answers which came in were very good. Go to QCAT in the minor debts jurisdiction. In that jurisdiction, QCAT has power to make orders in relation to amounts up to $25,000. I think QCAT was the popular choice. Another one was go to the Magistrates Court, minor claim. Court costs are lower and less formality. And of course, that depends on the jurisdiction. In Queensland, the Minor Debts Court has now been wrapped up into, and the Small Claims Tribunal has all been wrapped up into the QCAT minor debts jurisdiction. Other issues were, or other suggestions were along the same lines in terms of where we go. So is it as simple as that? Or do we, if we've decided and we've said to the client, all right, you're pursuing a debt for $5,000, can you think of any questions that we should reasonably ask the client which may colour that decision or influence the decision? Now, I'm looking for some ideas, so feel free to fire away any questions that you think you should ask the client before we initiate that proceeding in QCAT. So one is saying, I wouldn't go to court at all, even in the case of $5,000 or $50,000, just think of the financial cost and concern. And that's a very valid point. That does go back to the point that we raised last week about generating options. But for the sake of argument today, let's assume that the client has said, I want to go to court. That's my instruction to you. What someone says, well, we should say, how much do you want to spend? Is there anything that you haven't told me about the debt so far? They're very good questions, excellent questions. Anything else? What else do we need to know about this? Let's give a hint. What about the character of your client? Is your client a commercial client? Is your client a consumer? Does it make a difference? So we've got in the exercise which I've set, it just says you've got a hypothetical client, wants to engage in litigation, consider the appropriate court or tribunal, and your client wishes to pursue $5,000. So how much do you want to spend? Have you told me everything? Can you go to QCAT? Yes. I would ask if what they hope to achieve, what the financial compensation, or it's a matter of principle. That's a good question. What alternative outcomes would you accept? Yes. What would you be satisfied with? Can you prove the debt? Now, I like that response because we're now talking specifically about the litigation, whereas the other questions are great, but they're in the realm of generating those other options. So assume for the moment the client is determined to go to court or tribunal. Are they prepared to fail or come in second? Now, why would that be relevant? Can anyone think of a reason why coming second, getting the silver medal, may be relevant in terms of financial or risk? They may have to pay the other side's costs. Excellent. Because you might lose. All right, so just because your client says, I want to pursue the debt, it's not just a matter of saying, thank you very much, I'll have that ready for you this afternoon, you can sign it. I think the point is that you need to go further and provide the client with more specific advice in relation to some of the issues. And costs is definitely one of them. So there are all those other issues that people raised, but I think costs is a very good one. Make sure it won't put them in difficulty regarding their finances. Yes, adopt that holistic approach. Like, if it's given that you win, is it a given that you will win with the facts you have? Well, yes. I guess that raises another issue, and that is before you initiate the proceedings, do you believe that you're legally, morally, ethically bound to provide some idea of prospects? And I think that's a valid point. So we need to ascertain the likelihood of success. So we don't just go and march off, because if we come second and there are cost ramifications, and your client goes to the Legal Services Commission, the Legal Services Commission may well say, and probably would say, even though the client didn't ask you for your advice as to prospects of success, you're duty bound to have given those prospects. All right, anything else? I'd ask about the discrimination situation. Oh, look, can I just say, I'm going to make this a bit easier. Anti-discrimination will not be on the paper. So the fifth one, we probably won't get to that tonight. And there's a few smiles. All those people that have done hours and hours and hours of work on anti-discrimination. Sorry. Woohoo. Oh, so the people that didn't do the work on anti-discrimination are happy. Okay. All right. Now, what other questions do we have to ask? Your client says, yes, I've got a debt for $5,000. You've said, all right, we've explained the costs. Yes, I understand the costs. I may have to pay costs. Do you say, are there costs ramifications in QCAT as well as a court? Do you have to go to QCAT, or can you go to a court as well? Any thoughts? Oh, we're quiet tonight. You can go to court, yes. You can go to both. You can go to court or you can go to the tribunal. It is possible for the court or the tribunal to order that the matter be transferred from one to the other. And in some instances, certain debts are required to be pursued in certain jurisdictions because that's in the legislation. But generally speaking, if you've got a debt for $5,000, you can go to court or you can go to the tribunal. How much will it cost to go to the court compared to QCAT? Great question. Generally speaking, much cheaper to go to QCAT, which is part of its reasons. Preferential to keep it in QCAT. I think the consensus is if you can go to QCAT, let's go to QCAT. I think that's the general consensus. And it's very unlikely, or much less likely, in QCAT that there'll be a costs order if you come second. If you lose, you're probably not going to have the same degree of risk of a costs order against you as you would in a court, where it would be almost automatic. In QCAT, generally speaking, costs are not awarded, but they certainly can be. All right, we still haven't asked all the relevant questions. If you get a decision in QCAT, you still have to seek a judgment from the court to enforce it. Yes, that's a really good point. And that may be an advantage of going to the court straight away, because if you receive a judgment, then you can enforce it directly through the court. Whereas if you get a judgment in QCAT, you need to transfer it across to the court. So there is extra cost. But despite that, I think it's still better to go to QCAT, generally speaking. If you lose, you may get a countersuit, yes. It's a better risk profile in QCAT, one comment, and I think that's right. All right. Now, I talked briefly, or I raised the issue briefly, of the status of your client. Does it make a difference if your client comes to you and your client is in business as opposed to a mum and dad client, if you like. Does that make a difference? And if so, why? Only on impression? Yes, it does. Yes. Why does it make a difference? Because I raised the issue, so therefore it must be. Is that the answer? It would make a difference to their financial situation. All right. Give me a minute. Someone's Googling to find out the answer. I'll come back to that. But generally, you're on the right track. So I think everything you've raised so far is really good. And if you have a question of this type in the exam, then all those sorts of issues can be very correctly raised. Corporations can be wound up through no payment of debts. Yes, that's correct if you want to take the very aggressive route of a statutory demand. Now, that's not so much the status of your client chasing the debt, but that's more to do with the status of the debtor. So if the debtor, which is owing money to your client, happens to be a company, then maybe you bypass the court altogether or the tribunal and you go straight to a statutory demand. I think it'll be perhaps the outcomes might be administered differently if the complainant is a company. That way they can take security against you. So they're issues, yes. All right, let's go on to the next part of the question. Same scenario, but your client now wants to chase $50,000. What do we do? Where do we go? The consensus in the answers is we go to court. What court do we go to? Or can we go to the tribunal? Mag Court claim, file a claim, Form 2. Magistrates Court can hear up to $150,000. Someone's been doing a lot of homework. Very good. Any other suggestions? On the website we have claim and statement of claim in the Magistrates Court, issues regarding costs. $50,000 may be worth the while, but $5,000 may not. All right, well again the question is there an issue regarding the status of your client when considering which court, and if so, why? Is there an issue regarding the type of claim that your client seeks for the amount of money? That's another issue. Are there any preliminary matters that need to be at least discussed with your client before you pursue the matter? Depends on the maximum financial recovery. They want a stake in something for $50,000. Send them a letter of demand. Yet do that at the start before you issue proceedings. That's an important point. Before you issue proceedings, do send a letter of demand, and that way, if they then immediately concede the debt but refuse to pay your legal fees, they may be successful in resisting the legal fees because you didn't send them a letter of demand. Their response might be, of course we would have paid if you'd sent us a letter of demand. There was no need to sue us, so we're not paying all those legal fees that you've added on top. Can Magistrates Court hear matters for damages in some circumstances? Can they hear equitable outcomes? Generally, magistrates don't have equitable jurisdiction. Have an evaluation of the case. We must see some evidence of the alleged debt. So they're all good points. And I'll come back to that and make some further observations a bit later. Next one is, your client wants to sue as a result of a faulty refrigerator worth $2,000. On the website, most people say QCAT, that is, it's a consumer and trader dispute. QCAT, going to court would be too expensive, won't be cost effective. Others saying more practically, no, write it off. Otherwise, if we had to go, QCAT would be the best. Go to QCAT, but consider the operation of sections 55 and 54 of the Competition and Consumer Protection Act, which gives a number of alternatives. So there's some of the options that have come through. Expensive fridge, if you have to pay a lawyer, yes. Have an evaluation of the case, try to talk to them first, see if you get some agreement. Now, some of those things are really to do with those issues from last week of thinking of all those other issues. But if your client says, no, I want to proceed, I think the consensus is we go to QCAT. All right. Now, there's no QCAT equivalent in South Australia. That's right, Tim. I reckon there will be soon. But Magistrates Court have lower costs for debts under 25,000, no legal representation, similar to our previous small claims tribunal in Queensland. Fourth and final scenario for today, your client wants to sue for faulty motor vehicle worth $30,000. Does that change the issue? On the website, most people said, well, here's a different one. Federal Court was one. Magistrates Court. Magistrates Court might be more economical. Another was Magistrates Court, up to 150. Magistrates Court. And we have now mention of the Australian Consumer Law, which is very good for the cost of the vehicle, consequential loss, and potential damage. So, any other comments that we wish to make in relation to those things? All right, now I've just got some notes for myself, and I'll just go through these in no particular order. Firstly, I just want to speak to you about loan and credit agreements in the context of chasing a debt. I think it's important that you ascertain whether or not the client, your client, is a credit provider. Because if your client is a credit provider, then the National Credit Code provisions may apply, and non-compliance with those provisions may mean that your client's case is doomed from the outset. I gave you the exercise a little while ago of chasing down and finding the Australian Consumer Law. I trust we all did that. It's an important exercise. If you have time, try to track down the National Credit Code. And I'll give you a hint. It's Schedule 1 of the National Consumer Credit Protection Act of 2009. So it's a bit like the Australian Consumer Law. The National Credit Code is a schedule to an act, and it has now national application. So it's really worthwhile looking at that. And the reason I'm raising it is this. If in a debt, let's say for $5,000, your client pursuing the debt is a professional credit provider, before you issue proceedings, have a look at the National Credit Code, make sure that your client has complied. If it's the other way and your client is being sued for $5,000, then again, if the creditor is a credit provider, just check whether the code has been complied with, because it may be an easy victory for you in escaping that debt. So let me say this, that I don't want you to go and do a whole lot of research on the National Credit Code. The point of this exercise is this. It's to open up your mind to the very real possibility that in certain circumstances there will be more than the obvious that you need to consider. So last week, client came in and said, I've got a legal problem. We found out as a result of brainstorming exercise that there are many more options than just the obvious of going to court. Now we've narrowed it down and your client says, I want you to go to court. Again, keep a broad perspective. Before you issue the proceedings, just think about whether legislative requirements may have a bearing on your decision to go to court or not to go to court, and the prospects. So the National Credit Code is a very important one to consider. So the code applies, but you don't need to know this in detail for the exam at all. But I will just go through it relatively briefly. The code applies to the provision of credit, where the debtor, that is the person owing the money, is a natural person or a strata corporation, but basically a mum or dad, and the credit is provided for personal, domestic or household matters, or various other things like buying a residential investment property. And there's a charge for that credit, and here's the important thing. The credit provider provides the credit in the course of a business of providing credit. So it's not just every business, but only those businesses which where the credit provider is in the business of providing credit that the Act applies. Okay? So if you're acting for a bank and they want you to chase someone, make sure that your client has complied with the NCC. And that's all I want you to know about it. I don't need you to go, but have a look, just find it, but you don't have to study it in detail. you're a very conscientious lot, and I know what you'll do. You'll go off and you'll really plough through it, and I don't need you to do that. QCAT's jurisdiction. QCAT does have jurisdiction to deal with matters involving the National Credit Code, and there's a case which decided that QCAT is a court for the purposes of the National Credit Code. There are some licensing requirements for a credit provider, and in certain circumstances, if certain provisions of the code aren't complied with, it may result in a criminal offence being committed by the financial institution, and it may result in action being taken by the Australian Securities Investment Commission. So there are certain key requirements, and there may be some civil remedies which include the application of civil penalties. Okay, so I'm getting in too deep in terms of NCC, but I think you get the picture, that you need to consider that in terms of taking the matter further. I'll just say that in QCAT, there is a very wide-ranging jurisdiction to deal with credit issues. Some of those include equitable remedies, such as declarations for relief of debt, or mandatory injunctions in terms of returning goods. So the jurisdictional opportunities available to members in QCAT, which include equitable remedies, are not available to magistrates who don't have that ability. Another thing is this, and this is an important thing: just before you chase that debt for $5,000, you've got to ask this question, and you think to yourself, how do I remember all this? But you will, over time, remember these things. If you're chasing someone who is being sued for non-payment in a guarantee situation, there is another preliminary issue, and that is Section 56 of the Property Law Act says any guarantee must be in writing and signed by the guarantor. So if your client says, chase this $5,000 because Joe Bloggs' mum told me that she would pay, and if he didn't, and he hasn't done, so now I want you to sue her, you say, well, let's not do that because the guarantee was not in writing and it was not signed by his mum. Any questions then? There are other issues coming up on the website. Go to AustLII. Someone's found the National Credit Code already. Well done. That's from Jason and Tony. In relation to the debt motor vehicle, approach the Ombudsman. Yes, that's an option, but of course that's last week's option. That was in terms of the overall brainstorming aspect of it. Okay, so the point of the exercise there is that the status of the amount being sought can be relevant. So the type of debt may be subject to special rules, and you need to consider those special rules before you apply. That's to do with the recovery of an amount which is loaned. So that caters for, in general terms, options 1 and 2, or issues 1 and 2. But I agree with everything else that was said. Just in summary, if the amount of money that's being pursued is $5,000, then in general terms you'd go to QCAT, although you can go to the Magistrates Court, and I'm talking Queensland jurisdiction here, of course. If the amount of debt is $50,000, then in general terms you would go to a Magistrates Court. You would not go to QCAT. However, there are other exceptions. We talked about the status of your client as being relevant, i.e. whether your client is a credit provider or not. The question of QCAT versus court can also be dependent upon the nature of the debt. And let me explain. The minor civil disputes division of QCAT relates to essentially debts which are other than certain type of specific debts, such as a debt pursuant to a domestic building dispute. Now, in a domestic building dispute, QCAT has essentially unlimited financial jurisdiction. So that means that if you've got a client who wants to pursue a debt for $50,000, which is an unliquidated debt, and I'll come back to that, in relation to a domestic dispute, then you can still go to QCAT, and you probably, in fact, you should go to QCAT, even though it's $50,000. Now, I need to stop and just explain a few things there. I mentioned this term unliquidated debt as opposed to liquidated debt. It's a bit technical now. I apologise for this. Unliquidated means you've got to prove it. You've got to show, you've got to adduce evidence, and the tribunal or the court will determine a figure based on that evidence. A liquidated debt is one where the amount can be claimed readily. So if you're sitting on a straightforward debt, I owe you $5,000, then it's straightforward. It's a liquidated debt. But otherwise, you need to establish the amount of the claim. So if it's a domestic building dispute, even though the amount might be $50,000 or more, then given the nature of the dispute, you can go to QCAT. So what I've wanted to do there is, even in a straightforward debt situation, you need to consider the status of your client, and you need to consider the type of debt, because that will have a bearing on jurisdiction. All right, now let's move on to consumer matters and the supply of goods and services. So we've got a faulty refrigerator, faulty motor vehicle, 2,000 and 30,000. So QCAT, in dealing with goods and services, can deal with debts or liquidated demands, as I've just described. They can deal with consumer or trader matters, but generally speaking, up to and no more than the prescribed amount. So generally speaking, in QCAT, we're talking $25,000 as the jurisdictional limit, subject to that exception that I talked about with domestic building disputes. And also, it's got to be a debt or an unliquidated, a debt or liquidated amount or claim, or a matter involving a consumer or trader in relation to consumer issues. I know that's very difficult. Unliquidated, like an amount that's been charged by a plumber, yeah, it's really tricky, this whole liquidated versus unliquidated. But I guess the rule of thumb is that if you need to come in and adduce evidence as to how the amount can be claimed, then generally speaking, it is unliquidated as opposed to liquidated. I'll provide you with some notes on that on the website to better explain it, hopefully. All right, so we need to consider the law which applies in relation to supply of goods. We certainly look to the Australian consumer law. We know how to find that, and that will be relevant to it as well. And there are a whole lot of issues that are raised as a result of looking at the Australian consumer law, but it's probably a little beyond the scope of what we're trying to achieve here. The main point of the exercise was, as I indicated, understand the nature of your client and the business of your client, and understand the nature of the debt that you're wanting to pursue before you take the matter further. And if I talk more than that, I'm very liable to confuse myself, let alone confuse all of you, and that will go beyond what I want you to achieve in the examination. So for the purposes of the exam question, I think those comments that I've made already are sufficient. Are there any questions? Oh yes, now there's a question about the Competition and Consumer Act. Yes, the Australian consumer law is from memory Schedule 1 to that Act. And we went through that exercise of finding it before. Now, how are we coping? Does anyone wish to ask a question on camera? Any further questions or comments coming through on the chat line? In the exam, you don't have to consider the Queensland jurisdictional situation. If you're from a different jurisdiction, by all means, refer to your own jurisdiction. I want this to be an exercise that's useful for you, and I'll adjust. You don't have to. Notifying the merchant that you know the Australian consumer law and willing to enable to take action may resolve the issue without needing court. Absolutely. All right. Well, I hope that you've found this exercise not too daunting and reasonably helpful. I did intend for this to be a relatively short session because I know that you're very busy and I don't want to overwhelm you too much. Next week, we'll talk about chapters 8 and 9 of the text and the ethical issues involved in proceedings with court. Even though I'm saying court, there is more general application, of course. It's just that court brings it to a head, as it were, and it becomes very public. So that's where you need to be on your game when it comes to dealing with ethical issues. Okay, well, if there's no further questions or comments, I might stop the recording now, and we'll see you next week.